What is an evidentiary hearing? Hi, I'm Jeff Lee. I'm a trial attorney practicing here in Memphis, Tennessee, and I'd like to answer that question. What is an evidentiary hearing? An evidentiary hearing is a general category which includes any kinds of hearings with which evidence is being presented for a trier of fact. Now, a trial can be an evidentiary hearing. Usually when people discuss evidentiary hearings, however, they're talking about some sort of pre-trial hearing. For example, say that you've been charged with a DUI and you want to file a motion to suppress and you want to have a suppression hearing. During a suppression hearing, your attorney will present evidence of why you believe it was a bad stop, and any evidence that was found during that stop should be excluded from admissibility. Maybe that way you can get the blood alcohol to not be part of the trial. That's one example of a suppression hearing, and a suppression hearing is an evidentiary hearing. Now, why am I telling you this information? I'm telling you because you may feel like the best way to go forward in your case would to be having something like a suppression hearing, but you don't have an attorney, or the attorney you do have doesn't think that's the best approach. Now, a suppression hearing or other kinds of hearings are not always the best approach, but you need to understand why it's not the best approach if you're going to forego an important procedure like an evidentiary hearing. Here's what I want you to do. I want you to pick up the phone and I want you to give me a call, and I want you to say, Jeff, I feel like the best way to go forward in my case is to have an evidentiary hearing. Hopefully, some of the evidence in my case can be thrown out prior to the trial because it's prejudicial, and I don't think that my chances are as good if the jury's to hear is evidence that should not come into trial. If you have evidence that you want excluded, you can't throw it out after the jury's already heard it. Those kinds of evidence need to come out prior to the trial. The judge needs to have already issued a ruling that that kind of evidence cannot be admitted during the trial. I hope that this video helps you. I'm Jeff Lee, and thanks for watching.